Hello, everybody. Good to see you. Good to see you. See some people that see some familiar faces. Thanks again for joining us, everybody. We'll just give it a minute. But Mark, how are you doing?
I'm okay. You're not drunk, are you, Sean? You look a bit drunk. It's
Yeah, I woke up in a weird place today.
okay. Yeah. Well, obviously, yeah. No, yeah, sure.
It's cold here.
Are you one of his elves, or?
Yeah, well, that's why we're talking about employment today. So I want to make sure that I'm getting the best of what Santa has to offer here.
Yeah. Well, I'm not sure if Santa has compliant employment practices. I think he's a bit of a slave to it.
Yeah, I think he owes me some overtime. So what are you doing? Any plans for the holidays?
No. So yeah, I'm in London, and so they went back into lockdown. But yeah, just kind of you're stuck at home. But somehow the government says you can go out for 5 days and get everybody sick and spread the virus. So I'm not really sure what they're getting up to here.
Well, better in London than in the North Pole. I'll be working nonstop this week.
Yeah, well, that's good. Sure.
That's good. All right. So, yeah, thanks again, everybody, for joining. The past couple episodes, we've been focusing a little bit on JV disputes, which might be a little bit more of a niche topic than you might be used to or might be interested in. So with this closer look at employment law in China, we're going back a little bit to the roots about business law in China. So just to go over some of the housekeeping before we kick it off, Mark, this thing that we do here is we want it to be as interactive as possible. If you have any questions at any time, just put it in the chat. I'm constantly looking at the chat log here, and I'll find an appropriate time to ask Mark the question. We think that this topic might be a little bit more general, so hopefully there'll be some more questions this time around. But yeah, why don't we just start it off with a common theme that we're doing here. Mark, this is from your book, I believe.
I mean, not my book. I think it was a book I bought for 25 RMB or something. Yeah.
I'll send you a copy of it if I can find one for 25 RMB. But these pictures are great. Since we're talking about labor, I mean, I wanted to find pictures from the book that reflected that. So I mean, these pictures you can't even describe with words. And Mark, I put in the bottom here, the PRC Labour Law was passed in 1995, right around the time of that first picture, and then the Employment Contract Law, separate piece of legislation, was starting to be reviewed in 2005, right around the second picture there. Do you mind giving us a little bit of context here about what was happening in China or in Shanghai around that time of when these pieces of law that we're going to be talking about were being discussed or were passed?
Yeah, so I was working in Shanghai in '93 is when I actually arrived in Shanghai, and so God, I thought it looked better than those photos. But anyway, I guess those photos don't lie. But obviously things were very different, and I think the labour law. So I couldn't see the bottom of the screen. I think it was 1995 that it came in, and back then, very few people, I think less than 10% of people, had formal employment contracts. And so I think that labour law, it was one of the first big laws that did have an impact on foreign businesses. And back then in '95, there weren't that many foreign companies in China. So, foreign companies felt they were very important, but there really wasn't so many of them. And I think, probably one of the most important thing with the employment contract, employment law, was that it required you to have a written employment contract. and there was this penalty that you would have to pay double salaries. And so I think a lot of those things, when that law came out, one thought it's not going to really change anything, but it really did change things relatively quickly. So so I think now it's almost unthinkable that people don't have formal employment contracts. And I think, I don't know which law it would have been, but there was a bunch of employment laws over time, and then they increased the minimum wage. And, very often business, at least the foreign business, because that was the one which was, talking about it the most, they were all saying, oh, this is going to make China unattractive for business. It's going to make it unprofitable. But of course, I think it was the right thing. And I think now everybody knows it was the right thing, because otherwise, normal Chinese consumers and people wouldn't have benefited from the economic growth. So I think the government did a good job by bringing in all these protections and social contributions.
And I think that'll be one of the common themes that we'll talk about throughout this episode is the protection of the employee to the I don't want to say detriment, but in opposing to the in opposition to the employer. Mark, and just out of I put this last question on the bottom here, more of a personal curiosity. How did the lawyers react during that time? Because I think in employment law we take today for granted, but how are lawyers taking this piece of legislation?
I think it would have been only after that employment law came into being. It would have been like a couple of years later. I think at King and Wood, for example, we had the first dedicated employment law lawyer. So before that, I don't think it was really a practice. I think maybe it was a very small practice, and that practice didn't grow massively within King and Wood, but it showed that we don't have anyone who just does supply contracts, but employment law did become its own kind of department. So I think it did get recognition from lawyers that it was important, and all the big law firms have at least a few employment law practitioners. So I guess that shows that it does matter.
And if you're interested, the book again is A Changing Shanghai. And Mark, I think I just want to kick this off by kind of setting the scene here about your experience, and correct me if I'm wrong, but you weren't in that employment department. These lessons from the book that I've been reading are more so your lessons that you've picked up while working with the employment department or with your clients. So we don't want to get too much into the nitty-gritty details of what goes into an employment contract. But of course, there are some formal requirements and some very basic things that we should probably discuss in an episode like this. So Mark, would you please?
Yeah, sure. So I think I think it actually, if you're a corporate lawyer, you do delve into employment law. So I think if somebody wants an employment contract, in the corporate department, people will put together an employment contract, or they will review an employment contract. I think it's really only if it's a dispute or if it's a very specialized question that the employment team does that. So I think we have done quite a bit of employment law over the years. So I think perhaps the things, if you look at an employment contract, I think things which are probably important that a lot of people wouldn't think about is the term. And I guess there's a real difference between how Americans look at contracts and Europeans look at contracts, and then the China experience. So a lot of American clients will just have open-ended contracts because they're familiar with terminate at will, employment at will type of arrangement, where they can just give you 2 weeks notice and you leave. But in China, it's very hard to terminate contracts, and on the third renewal you have an open-ended contract, and then those people are difficult to terminate. So contract terms are very important, and it also has a relationship to the probation. So I think that's one of the first things is to think about is how long your contract term is. I think mostly people would do an initial term of 2 years is normal and have a probation period. I think job description is important. A lot of people think that's strange, but it is important to set out what's within the scope. Labor protection, work conditions, this is all just template. Remuneration, also can be a little bit complicated. Sometimes people forget to write if it's gross or after tax and things like that. And then, what's perhaps very important in China is the termination conditions. So, it's important to spell them out. And I think because, China is developing a little bit more like precedent, but it's not binding. So it's important to spell out what would be causes for termination, because I think it's sometimes very frustrating. We would have a case where a manager would give his elderly mother a contract for consulting for the company for 2 million renminbi. And, we found it difficult to terminate him because it didn't say in the contract that he wasn't able to, have these kind of conflicts. So I think it's important to spell these things out. So that's like on the must-have column.
And I noticed that you also in the book have a section of what's nice to have in a contract, and these might be things that are not necessarily spelled out in the letter of the law, but should probably be included.
Yeah. So I think, look, I think a probation period, you don't need to have it, but you should have it. And that'll depend on the term. So I think the maximum is 6 months, but that would mean that you have to have like an initial term of like 5 years, I think. So normally it's a 2 month or so probation or 3 months probation. And within probation, you can, without any issue, terminate the employment relationship. So it's important. So, it's because it's going to be difficult, and we'll talk about it a bit later, I guess, to terminate contracts. That's important. Something else is the repayment of training costs. This was probably more important a few years ago, definitely not so important this year. But, what would happen with many foreign companies was that Chinese employees would see it really as a major benefit is if they would be able to travel overseas for training. And this was quite expensive. And problem was very often the perhaps Chinese employee would go overseas, get the training, and then find another job while they were overseas. So it's important at least to put in the contract that they'll have to repay those training costs, and it's normally pro rata. So if they stay for 5 years, they won't have to repay anything. If they leave immediately, they'd have to pay it in full. So I think that's an important one. And then I think the employment handbook, it's really only if you've got a sizable business, I'd say 20 or so people. And the important about the employee handbook is you can put in a lot more details about how you expect people, to behave, etc. Now, I think the ones which I say is nice to have is the confidentiality clause and the non-compete clauses. The problem with these is it may be nice to have, but probably very difficult to enforce. And with the non-competition clause, to make it actually enforceable, you have to pay a certain amount of the salary, and the period of time has to be reasonable. And I think, look, my experience to date has never been that these things really work. So we had a issue once where somebody had changed employers, went to a direct competitor, and the litigation team said, well, what you really need is you need evidence of him, working at this place. So the guy somehow got a video of the ex-employee working in the front, office of this competitor, and they brought it back to the Chinese litigator, and the Chinese litigator said, the problem is this evidence is no good because he's not holding a newspaper. And he said, well, why would he have to hold a newspaper? He says, well, then we could tell what date it is. So I think the problem with non-competition clauses are they can be expensive. You have to pay money. And if the employee wants to compete, he probably will compete anyway. So I would put them in, but not make them mandatory. It's more like if at the end of the contract, I wish you to not compete, then I will pay you on a monthly basis, whatever the relevant minimum is. I think in Shanghai it's 2/3 or something. So I think they're the kind of clauses that one could look at.
And we have a question from Ralph, which goes to the non-competition topic too. And I also have a question as well. Do you believe that this um, lack of enforceability of the non-competition clause is something that is rooted in the whole protect the employee stance of the employment law, or is it something else that you think, Mark? Or
I think it's not really about protecting employees. I don't think. I think it's more about, in China, it is not easy to enforce things, and it's not easy to enforce things against individuals. And people are able to do things and get around things relatively easily. So I actually should ask somebody in the West how easy it is to enforce these. I would think it's probably not easy anywhere. So I think it's not a bias on the courts towards it. It's just part of that problem of making it's very difficult to enforce against people in China. China may well get easier on this because they're talking about next year increasing new regulations that secure better trade secrets. And I think this is one of the issues with the non-competition, because a lot of people have a strange philosophical view of non-competition. I think as lawyers, you have to realize non-competition clauses are not good clauses. They're not really good, because you really can't tell somebody, all because they've worked for you for a period of time, they can't work and do that trade going forward. That's really their lifestyle, and that's their right. I think the non-compete is legitimate in that it can stop somebody from taking away existing customers, taking away trade secrets. So I think a short non-compete would say 6 months or something. That makes sense to me because it would disrupt things a bit. But I think, if you're worried about trade secrets or other confidentiality, these should be addressed in other ways, not trying to seek somebody not being able to work somewhere.
And we will get into a little bit some of your recommendations in the next couple slides. But Mark, you did say you wanted to know how someone from the West would view enforcement of a non-competition clause. And Ralph says in the comments that non-competition clauses are used in Europe, but in disputes, the court judgments in Germany tend to let me just read exactly what he says. Court judgments in Germany which say that in these cases, the former employee has to pay the salary over the whole non-competition period, something comparable in China. And a question from Alan on how to enforce a non-competition clause, particularly in comparison with the Australian regulatory environment. We'll get into that a little bit, Alan, but thank you for the question.
We can address that quickly because we'll forget otherwise. Look, I think the non-compete, there's lots of issues with non-competition. So one of the other problems is, the forum normally for labor disputes is the labor arbitration. And those people would tend to have a pro-employee bias anyway. So that's one of the reasons. If we talk about also what Ralph said about, like in Europe, you have to pay the full salary or whatever, and it has to be time limited, as I think what you also mentioned. So these are legitimate things. So I think, you can't have this mindset that some people have as employers that you should be able to deny somebody to work. So I think if we're going to talk about denying, legitimate rights, so one of your legitimate rights is trade secrets, customer lists, this kind of stuff. This stuff should be in a separate contract. So what I would do, and we haven't put it in here, but it's actually an interesting point. If you've got somebody who is doing R&D for you or somebody in the IP thing, what I've always done is I have an employment contract, but we have a separate standalone type of confidentiality proprietorship agreement. And the reason I put that separately is because there's certain rights that employees get as inventors in China, which is similar to the German system, but different from America or UK. And so I want to have a standalone contract where I can go directly to the court and seek redress that way, rather than having it in the employment contract where I go to the Labour Arbitration Commission. So, I think the thing is, for most employees, it's not a big deal, but if someone's in a sensitive position or is doing IP, it's worthwhile thinking a little bit out the box how best to protect yourself.
Yeah, that's right. And we'll get back to the slide later, but this is the part that we covered here in number 3.
Yeah.
All right. So very quickly, Mark, I know you touched on some of these already, but maybe you want to go into a little bit more detail, or would you rather just skip
Yeah,
this?
okay. Maybe it's worthwhile just quickly on these. So I think
Sure.
the term of contract, we've already covered it. So you can have a fixed term, open term, or a term determined on a job basis. I've never seen that last one. I mean, I assume they exist, but I've never seen them. So I think, by now, 90% of people know you should have fixed terms, but we still come up with people writing to us, and it's almost always when they want to terminate an employee, and then we find out they have an open-ended contract. So that's probably the single biggest kind of mistake people make. Probation period, important to have and important to act during the probation period. And it's incredible how often people wait till the last day or so, and then it's too late to get things done. So, check beforehand, and it can get complicated. Sometimes people try to extend the probation period, but because depending on the local requirements, probation period is often tied to the term of the contract, it might be invalid, and then you might find it difficult to deal with the employee. And then with remuneration, it's just like, what's gross salary, what's net salary, what bonuses, what's discretionary, will the FIE withhold the tax, overtime paid? I think that this doesn't come up as much as you think, but these are still things that should be ironed out because they can be complicated to deal with.
And Jack, you have a question on pension benefits and insurances, and I think we'll get into that a little bit in the next couple slides, but thank you for that question. Mark, in the book that you wrote, I wonder, you wrote this book 15 years ago, and I just wonder how much of it is still relevant today. It seems that most of it is still pretty relevant. Jack's question about pensions and other types of payments on behalf of the employee by the company, which is number 1 here. This list of 7 common issues, do you think that these issues are still pretty consistently, encountered today?
Yeah, I think probably there was a mistake, but it was probably always the case, but it's not on that list. Yeah, the obvious one is actually terminating an employee.
Yeah.
So I think that's number 1. And that would have been also the main problem. But I would say, the social insurance contributions, less so. I think, again, that's something where, nobody used to pay at all. And now, I think most companies are like 95% compliant. Sometimes it's hard to be fully compliant, but I think most companies are compliant. And even we do due diligence, for a private enterprise, it's not that they don't pay anymore. It's normally that they underpay the social contributions. So they use a lower base than the actual salaries or things like that. So I think, it's really gone from, it used to be people didn't pay at all, or people, just, lied about the number of employees or did things like that. So I think that social insurance contributions, it's pretty regulated. And in a due diligence, it comes up and then you have to calculate things. But, it's improved a lot compared to what it was like 15 years ago.
And Mark, termination is probably the number 1 issue, which is, I think, so big that we've dedicated a little bit of a separate section to it. So we before getting into that though, we have some scenarios where we've seen this type of issue do come up, because it's not always just the single individual employee, but sometimes it's massive numbers of employees that need to be terminated. So Mark, what are some situations that are commonly you've commonly encountered that require such approach?
Yeah, so I mean, I think we haven't seen it perhaps as much as people thought with this COVID. I think earlier in the year we saw a number of people exiting the Chinese market, but liquidations, I can't really think of a liquidation that led to a complete withdrawal from China. So some clients have really closed down downsized their business, or right-sized the business. So I think that's what we see quite a bit. And I think, liquidation is a good reason to terminate somebody. And so, if we just take a step back and talk about termination, there are a number of legal requirements for termination. And, something like if you've, committed a crime. But, the most common one is that you've been given a warning and you haven't performed, and they gave you training, you're still not performing. And these are very subjective. So I think it's difficult to terminate employees. And I think what most people do is they would do a mutual agreement. So you pay the person something and they leave, or you wait out until their contract expires. Now, with companies that are facing economic problems, so they want to downsize, I think it's a bit similar. So we've had I think all the liquidations we had, even though you have a legal way of doing a mass layoff, I haven't seen one. I don't even know if people still really do them. It's in the law, but almost all the liquidations that we've been involved in, we've always negotiated with the employees, and you pay them the minimum severance. So severance is 1 month of salary per year served up to 12 months. And so if we call that N, I don't know why it's called N, but everybody always refers to that number as N. And then they will say N plus X, whatever that's going to be. And so I think most people end up paying, the month per year served plus 2 or 3 months, depending on the negotiations. And so I think it's important that everyone gets the same kind of deal. And that's how we've dealt with those dismissals. It's rare to go through the mass layoff route, because you have to deal with the government. Everyone gets upset. Yeah, so I think, even in a liquidation, people still end up paying more than the severance to the employees.
Yeah. And I think we might get into it a little bit later in the slides, but negotiating with these employees too is kind of a whole separate issue that is a little bit beyond the scope of the employment law and the employment contract law, but very relevant to these types of scenarios.
Well, there's a lot of strategy involved. I mean, I won't go into length into it, but basically you have to work out who are the people. And like I said, it's rare that people really do a liquidation, even if they think they're going to do a liquidation. Very often, I'd say 8 times out of 10, they will actually downsize it to a smaller business. So you have to work out like who you're going to keep, and then who's going to be the troublemakers. And then you have to make sure that you announce in the right way. And most things are complicated. So you may close the first department. It's really rare that you just go in and just take everybody out on day one. So there's a lot of strategy, and there's a lot of finessing on the communication, and also working out in advance how much you're going to have to pay. And most liquidations we kind of do, or big downsizings, people actually have to put in extra capital into the company to make sure they have enough money to fund all these things.
And we have a question from Jack, and I think I want to ask this now before we move on. In M&A deals, so in one of the previous slides here, we didn't talk about it too much, but number 7 here, when a foreign company either partners up or acquires even a Chinese company, there is this idea of, you have to also take on the employees as well. So I don't know if that was what Jack was going to, but his question was, in M&A, is there a similar requirement like TUPE, T-U-P-E, in the UK?
Yeah, so TUPE, so I think it used to be different. And again, I guess that shows that, the China employment law has become reasonable over time, even if it's become a bit more expensive for business. So basically, one of the issues was, early on, you'd do a joint venture, the employees would leave the Chinese partner, join the joint venture, And that thing which I just mentioned before, severance, and also other things like the longer you work somewhere, the more of a holiday right you have. And there's all these other kind of rights that accrue over time. And so, it used to be just that the employees would just shift and then everything would restart and they get nothing out of it. So nowadays, if there is such an arrangement, you will either have to pay, or the original employer will either have to pay the severance and restart the clock, or the joint venture will have to recognize the historical rights. So, if I work for 10 years at a company and then I move to another company, either I get paid that, 10 months severance, cap, certain things, or the new company has to recognize it, and that's like a contingent cost for them. So I think we do have that protection now. And so I think, if we're looking at acquisitions, state-owned companies can be an issue. Privately owned enterprises, it's rare because privately owned enterprises don't tend to have too many people in China. So most it's when you've got a state-owned enterprise, they may try to push a lot of people onto the company.
And I guess one last question that popped up in my mind before we move off this topic is, so just to put a lid on it, over the past 15 years, Mark, do you think that the enforcement of this, of the labor law has been consistent and even been refined over the years, or how?
No,
what do you?
sure. I think absolutely. So I think really like 15, 20 years ago, there was not really employee rights. And now I think it's the most common issue we see that is a hassle is somebody wants to terminate an employee. We get an email like this every week, like literally every week we have one of these issues. So I think, these people know their rights. The barrier to entry is very low. So for an employee to go to the labor arbitration, it's very cheap, whereas the foreign invested enterprise, it's a big distraction. The lawyers for them is not cheap. They'll probably need a kind of a firm that's got a bit of an international feel to it. So it's a big hassle. It might not look like a big problem, but in day-to-day life, it's quite a major problem for lots of companies.
Thanks. And just to go back to the terminating employees topic here, and like you said, being in China, I can tell you that everybody knows their rights here, and I think that that's just evidence of how much this law has been embraced by the people. So on this slide, we talk about 4 different options where you can terminate an employee. Mark, you mentioned before, you can't just, this isn't at will employment, so there has to be certain prerequisites. Do you mind telling us a little bit about these different options here?
Yeah. So I think the mutual termination, I think this is actually in the backdrop of a liquidation, but I think if it's a senior person or if it's in part of like a liquidation, there's a lot of issues. It's always best to have a mutual termination, and often it won't be much more expensive than the unilateral termination. So I think that's one way that requires negotiation. The redundancy is this mass dismissal. I think it makes sense on paper, but I haven't seen it for many years. So I don't think it's very easily. And, it's also, what will often happen is if a company wants to liquidate, they have to get approvals to do this. And the Labour Bureau will look at it. And, we had one case where the company wants to liquidate and they've got, millions and millions of dollars in the bank account. They have a large piece of land with a factory on it, and they're not loss making. And so they're never going to get approval to liquidate in that way because, the government will say, well, why are you losing all these jobs? And it's in a depressed part of China. So, I think that kind of redundancy, difficult in practice. Unilateral termination is really more if you've got cause. And maybe you could say there's a material change to the objective circumstances, but it can be difficult. And then liquidation, like I say, that is grounds for termination. But again, it's very slow. It's a big bang approach. So you have to liquidate everybody at the same time. So again, I don't think it's very common. So for us, it's really going to be option one is by far the most common if we're talking about a large scale termination event.
And for option one, is that when there's requires heavy negotiation with the employees?
Yeah, I mean, I think this slide came actually from something about liquidation or downsizing of a whole firm. I think if we're just talking about individuals, it's really going to be either option one or three. And so, yeah, that would be, yeah, they fall into different buckets. So, yeah, it's often the employee is just like a poor performer over time. And, you know, that's difficult to subjectively show. And then there are other things like the employee has done something, you know, dishonest, but difficult to prove, you know, that smoking gun. So we had a case early this year where an American company, the sourcing director, it was clear that, I mean, I think anybody looking at it would have thought it was clear that this person had asked for, you know, kickbacks from the suppliers and all these kind of things, but they didn't have this smoking gun. And so in the end, we came to a settlement with that person. And so I think that's something which is difficult for people. I think with the non-performing people, it's much easier to agree a bit of a payment. But the real difficult is when you know that someone's done something wrong, but you're nervous about the unilateral termination because that person's going to be very likely to sue you. And in the absence of a smoking gun, you know, he'll probably win. And something which we should mention as well is if it's a wrongful termination, it's the employee has the right to ask for double severance, which I think is okay because that's a calculable amount, or he or she can ask to be reinstated, which of course is a bit of a nuclear option. So I think, yeah, that's very difficult for companies to get their heads around. So you could sack somebody and then the court could order, you know, 6 months later, they have to be reinstated. Now, there's ways you can try and minimize that risk about like saying that the position is no longer there or you filled the position, but there's still a risk, you know, on those things. We had an American company, it was a client, and they were using another law firm, and they just asked for my advice. And again, it was last minute. They just phoned up, and they were going to the court, and they asked me a few questions. They said, well, first thing is the Chinese lawyer that we're using, he told us that we shouldn't attend in court. And I said, oh, that's weird. I mean, like normally it's good because it shows you're interested. The courts kind of find it fun if there's a foreigner there. And they said, yeah. And the second thing is, you know, we've been arguing that the person's not our employee because the Chinese lawyer thought that the employee doesn't have a copy of the employment contract. And so anyway, I think it wasn't a surprise. And this was a big multinational company that did this. And so it wasn't a surprise that that person was reinstated by the court because I think that person could have shown name cards, emails, monthly payments of the employer. So sometimes people do very stupid things. So that's why I think, yeah, employment things can be very embarrassing. So check it carefully.
And I remember in the book that you wrote that, well, of course, this was 15 years ago, but the one of the things that is largely silent in the labor law is it kind of treats all employees as, you know, pretty equal. You know, do you see that there might be some differences or nuances in this approach here on the screen in respect to a blue collar worker versus a white collar worker? You know, how do you protect? Obviously, you as the company will probably be more exposed to certain risk terminating a general manager, for example, rather than just say, you know, labor. So, you know, how's your experience been in dealing with this latter example with the more white collar?
Well, I think with the white collar people, you know, it is I think a big failing of the employment law in China that they don't distinguish. So, you know, even the general manager, I think, has the same protection as a blue collar worker. And there are some subtle differences. Like if the person's replaced and there's a new person in the job, harder for them to be reinstated, but it's still a risk. So I think that's something which should be addressed, I would think, in the law. And I think the problem is also you can put stuff in the employment contract, but it's really hard to enforce them. So let's say the opposite. So we may have termination grounds, and I think that's good to have for a general manager. If you make it objective, like this is the KPI, if you can't meet it, you can be terminated. That's all helpful because even if it doesn't go to court, it's helpful to negotiate the termination. But the other problem is very often with managers, you've invested time in them and you want them to give you enough notice. And under the labour law, it's a 30-day notice period. So an employee can leave with 30 days notice. And look, we have in almost all of our management contracts 3 months or 6 months. But in reality, I've never seen anybody serve out the time. If they want to leave, they just give 30 days notice. Sometimes you're really happy if they even do that. They just sometimes just leave and just, say adios. So I think, I'd say that's a criticism of the labour law is I think that blue collar workers are put on the same level as white collar workers, where I think management should actually have a little bit more risk in their positions.
All right. And thank you so much for the questions, everybody. If you have more questions, just put it in the chat. I just want to wrap up this termination topic before getting to those questions. We have a nice little flow chart here, Mark, of how the layoff process kind of looks. Do you mind just giving us a high-level overview?
Well, I think this goes back to like how people do the strategy of the layoff. So some of these are legal requirements, and but some are just more the strategy. So preliminary discussions, work out what you want to do, review the contracts. Very often people haven't looked at all the contracts, look at the board resolutions, assess like what is actually the position of the social contributions with the tax, and then you have to like verify stuff. So I think first collect the information, work out your strategy, work out the costs, and that's quite a time-consuming issue. So you're going to have to find everybody's employment starting date, what they earn, bonuses and everything, and you're going to have to work out what the severance is. And then this is the formulaic way of how you get the employees to discuss with you, and then you negotiate the mutual terminations. And people misbehave everywhere. But one of the funny or interesting stories this year was we did have a big downsizing, and so the employer would have terminated over 1,000 people and brought it down to like 100, but it was in the retail space. And one of the interesting things is, retail employees, they tend to be, younger people, and a lot of them tend to be female. And anyway, something like, I think 50% of these female employees became pregnant, and, which seemed surprising to me. And it was relatively short term. And so I asked them, I said, well, we should get a copy of the ultrasound, picture or whatever. And of course, actually, the ultrasounds were all the same. So what had happened was somebody was pregnant, and then they just sent it to everybody because, pregnant women, totally justifiably are given special protections for employment. And so anyway, so all these young women were telling everybody they were pregnant just to improve the exit. But probably only one of them was pregnant, or maybe none of them were pregnant. They just bought a scan off a doctor. So these are the kind of things that can happen in a mass termination negotiation. And there also can be a lot of like emotion. So I remember, people trying to hit people over the head with chairs. We had one case where they held the foreign guy for 2 days in his office. Another case, the guy was in his office, he was hiding underneath the table for a couple of days. So, you have to plan these things. It's nice to look at the flowchart, but these are people's livelihoods, there's emotion. You have to factor in a lot of things before you, pull the trigger on these kind of things.
Yeah, I think we probably need a whole different episode on that, because I think one of the common themes, not just in this episode, but in all the previous episodes, especially the JV dispute part, is there's some overlap here, is that you're dealing with people and you're dealing with people's livelihoods, and it's not so easy to, just up and quit. So yeah, to say you need some strategizing is probably an understatement. So that's all that we had, but I want to get to some questions here. So Mark, I have a question here from James, and he was wondering about employer of records. So he says that in China there are companies advertising that they have employer of record services, and the goal is to avoid complications. When would you when would using services like this be advisable, and what problems could arise when using these types of services?
So I think what it might be is, I think there are these labor dispatch entities, and there's people like FESCO and all of these things. But the FESCO is the most famous. They've been around forever. So for example, if you open up a rep office in China, you can't hire local people directly. So you hire it through someone like FESCO, which is an employment services company. I don't think there's any magic to it. I think if I had a wholly foreign owned enterprise with, say, less than 15 employees, I would outsource the employment, the payroll and that stuff to FESCO, but only because it's easier to handle and it's better than having your own admin, and it'll probably get done correctly because that's their business. I don't think you can really, because the law changed, a few years ago, where if you were doing the same job, you had the same rights. And so, just if you were hiring and outsourcing it, and this company was not paying its social contributions properly or whatever, I think that's too dangerous now. And so I think, firstly, it's not legal anymore, so they have to get paid the same for the same jobs. And also the labor dispatch companies have really come under a lot of scrutiny over the last 5 years. So I think there's a role for them, but it's really only to outsource something which you're not very good at doing, but it's not a way to, cut corners on social contributions. And any legitimate company that does this would want a back-to-back indemnity anyway. So, let's say if I hire 2 people, then FESCO is going to have a contract with me that, if I want to terminate one of these people, they'll follow my instructions, but I'll have to indemnify them for any costs. So I think there's no real magic. It's not some trick that you can play.
Thanks. And kind of in the same vein here, another question. Many companies choose rep offices to enter, representative offices to enter China. FESCO and labor dispatch contracts are often mentioned. Can you explain how labor relationships and contracts work for rep offices in particular?
Yeah, so I think that's actually what I just was talking about. So the rep office is a strange beast. I don't think lots of people enter China anymore through a rep office. I think maybe 15 years ago, it was quite common. We see them now, but it's pretty rare. I mean, I think if we see 2 rep offices a year, that would be probably what it would be. And the rep offices, they also have had their kind of ambit a bit squeezed. So I think you can't hire more than, say, 4 people as a rep office, 4 expats at least. And because there used to be like some of the big logistics companies, because they were in a restricted sector, they would have these massive rep offices with 200, 300 people, but they're not supposed to be doing business. But the issue is this is all opened up, so people have set up their own woofies or they do joint ventures. So, but with rep offices, they're not supposed to do business, and so one of the issues is they can hire the chief rep or a foreigner they can hire, but if they want to hire local Chinese nationals, they don't have the right, so they have to go through FESCO. I don't think it's anything other than an old idea from 20 years ago. I don't think there's a real reason for it anymore, but that's why you always have to hire through someone like FESCO or a rep office. But like I say, I don't think there's magic to it. Basically, a rep office is small anyway, so it's better to have FESCO do the payroll, do the social contributions, make sure the tax is paid to the authorities, that's better than you trying to do it remotely from Europe or America.
Yeah, and just to echo what you said, there are certain limitations in using that, but that's more so for tax avoidance and other types of things. So don't need to repeat that. We have another question going back to the non-compete. Vincent asked, rather than have a non-compete clause, which might be hard to enforce, can you rather have a garden leave arrangement up to X months?
Yeah, I think I think it's all a bit the same. I think garden leave sounds nicer. It's what lawyers have. So lawyers have garden leave, and so basically it's just that you will work it out, and I think that's like the 6 month, and so I think that's probably better for high level people. So I mean, I think probably people do know what this means, but garden leave is you can't go to another firm. You stay in work, but people make you not. People stop you coming to the office. So basically, I think it's most common for lawyers and maybe executives, but more rare there. And so, I've never been lucky enough to get that, but I've always dreamt of having the 6 month holiday. But again, that's a bit like what Vincent said is, it's what I was saying a bit about the non-compete. It can't be forever. You just want to disrupt the relationship. So with garden leave, for the law firm, they would just want to stop the lawyer taking, these clients seamlessly to his new firm. And, I think it makes sense. But again, it will depend on who the opponent is. It's also not so easy to enforce.
And we have a little bit of a chat going on. So Ralph's asked a question. I once audited HR in China. They told me that all employer reference letters and school and university certificates are stored centrally by the government. Is that true? And Joseph replies, they could be copies stored centrally, but not necessarily by the government. The individual would also acquire copies of the certificates.
Yeah, I don't know the answer, but coincidentally enough, I was discussing last night with somebody. We're talking about I guess you call it plagiarism of certificates. I don't know if that's plagiarism or just forged, I guess might be the more correct term. But, in China now, for a foreigner to get a work permit, you need all those kind of university documents really authenticated and notarized or something. And I think it's because in China, there has been foreigners and Chinese alike have been forging documents for a long time. And that's one of the strange cases we did have is where somebody claimed to have a certain type of, qualification, and still that wasn't grounds for termination. And then I read another case where the person did it twice and they still weren't terminated. So, it's sometimes surprising what you think is grounds for termination may not be what the labor arbitration thinks is grounds for termination.
And I think I'll just quickly go here and probably right in this part here, the employee legally terminated his or her previous labor relationship is one of the requirements for the formal employment contract. This point can be tricky just because, not speaking from any particular experience, but just life experience being here, it is, employers can sometimes use this part as leverage in, making an employee who wants to leave their life pretty miserable because they won't officially sign off their termination. So I don't know if that's what you were going for in that question, Ralph, but hopefully that's useful. I think we have one last question here, and that has to do with foreign companies' relationships with trade unions, Mark. Is there a requirement for foreign companies to cooperate with trade unions, and how does that relationship work in general?
Well, I mean, my experience with trade unions was, the first years we never really heard about them, and I haven't heard much about them lately. There was a period of time where I think it's if you have more than 25 employees, you should have a trade union. But the trade union is a bit different in China than it is in the West. So, I think in the West, you think of trade unions as people organizing strikes and fighting for workers' rights. I think in China, the trade unions were mostly like in charge of organizing, movie nights and ice cream or something, So they weren't really the vanguard of, workers' activism, but rather probably something the authorities use to also defang a potential another type of power. So I think the trade unions, they don't really fight for improved conditions. I think, if people are doing wrong things, then they will perhaps step in or they may say something, but they're not there to try to activate for higher pay. And I think they can be useful to have if you've got like a mass dismissal, you have to do that. It can help because they will have a liaison with the local authorities. So I think the trade union is very different. It goes in fits and starts, I think. Sometimes the local government suddenly wants everybody to have a trade union, and then people kind of have to set them up. But, very rare that I've seen a problem with the trade union, to tell the truth.
All right, I think we got through all the questions there, Mark, and we're just about out of time, but I guess I just want to say to everybody while we wrap up here that this is the 9th episode of The Art of Law, and thank you so much for watching. You could be anywhere else in the world unless you're in London, but you're here with us and we really appreciate that. This will be the last episode for this year. We'll see you again in 2021. It hasn't been an easy year for anybody, but we do wish you all the best. We're rounding the corner here. And Mark, any last messages you want to say to all of your adoring listeners out there?
Yeah. Well, I mean, look, I'm a cynical old bugger. I do get a bit worried that everybody's saying, "Oh, this year was so bad. I just can't wait for next year. 10 days away, whatever it is." Unfortunately, I don't think the coronavirus is working on that kind of time schedule. So I hope everybody will stay safe. And it's been a tough year, I think, for everybody. But even though I've been stuck in London, I realise I've had it much better than many, many, many other people. And so it's been tough. I'm happy that we could see that China came out of it. So it does show that you can kind of defeat this virus, but it's a pity. I just hope everybody has a good year.
And we've had a good time just starting off this project, and at least one thing we'll take away from this year is this webinar series. And thank you so much for sharing.
I meant if I would have known that it would have ended like this with you in a hat and pretending to be in the North Pole, probably we would never have embarked on this. Sure.
I would have never have signed up, but here we are. All right. Merry Christmas, Happy Hanukkah, Happy Holidays, everybody, and Happy New Year. To you too, Mark.
Okay. Thanks, Sean.
Thanks, everybody. Bye-bye.